based on my past and things that happened in the past, that he finds my son's dad credible in what he's saying, and that's why he will terminate my service. Take a little story, Cal, and then a question to go with that. So I had my services terminated in November of this year. Although I finished my case plan, I went to treatment, did outpatient treatment, did domestic violence classes. I did everything in my service plan, but my son's dad, who's the other parent in the case, told our social worker that I was still trying to pursue a relationship with him, and we have a history of domestic violence, which I wasn't, and I have not seen him in over a year. But when the judge read his ruling, he said that based on my past and things that happened in the past, that he finds my son's dad credible in what he's saying, and that's why he will terminate my services. But my son's dad hasn't done one thing in his case plan, has not gone to treatment, hasn't, the only thing he's done in his case plan is duplication, and he's barely even made those, and he has a felony warrant for the domestic violence. Mm-hmm. So I just wanted to know, how can the judge find his testimony credible? It's not even his testimony because he never showed up for court, it's just what he told my social worker. And is there, what can I do? Because my lawyer said that she was going to file the writ, and I got the letter saying the intent was filed. Then I got another letter saying that it was never submitted, and that it was past the deadline. And so I'm just wondering, what do I do now in my case? Because I don't want to lose my son. I've worked so hard and completed everything in my case plan, and I just need to know what to do next.
Okay, I hope you have a pen and paper because I'm going to cover a lot of ground for you. Whenever your reunification services are terminated, or if you're not given reunification services, in California, you have to file a writ, a notice of intent to file a writ, and you have to do that within so many days. And then once that's done, then you have to file your writ once the record on appeal is completed. Now, you said something interesting. You said that you got a letter saying that your notice of intent to file a writ was filed, and then then you later got a letter saying that it wasn't. So I don't understand those two things. How could they be sending you those two different letters? What I would do is I would talk to your attorney, email your attorney those two documents, scan them, and ask the attorney to explain what's going on, or if the attorney or you should be contacting the clerk of the court to find out what's going on. But Ashley, have no fear. That's just on the issue of the termination of your reunification services. There are still things that you can do to get your reunification services instated, to even get, more liberalized visitation, and to even get the child back in your custody before your next hearing in 120 days, which is the 366.26 hearing. They call that the selection and implementation hearing. And at that hearing, the court, usually, not all the time, selects a permanent plan, and that permanent plan is usually adoption, where your parental rights would be terminated and you could lose the child permanently. So one of the things that I do is I advise people to immediately ask for a bonding study to help you get a defense in the 2-6 hearing. And then start filing 388s to get the child back, to get more liberalized visitation, to reinstate your reunification services, and to place the child with a friendly relative or friend if the child's not placed there now.
Okay. Yeah, my son is placed with my aunt right now, so that's good. So do I ask for a bonding study before the 2-6 hearing?
Yes, most definitely. You want to ask for it now. You want to ask for it now.
And do I ask my lawyer for that?
Yes.
Or who do I ask for that? Okay.
You ask your lawyer to help you file that motion, or for him or her to file that motion, and you do that as soon as possible. Don't wait until you get close to the 2-6 hearing, because then it will be too late.
Gotcha.
Okay?
Okay. All right. Well, then one other question, if you don't mind. Because I'm still fighting to get my son back and everything, but because my services were terminated, CPS helped me get into my housing, the program called Baby Families Home, and because they terminated my services, I got a call from my housing worker saying that I no longer am going to get my Section 8 that I had submitted all my information for. Mm-hmm. And I said, even though I'm trying to appeal it and still fighting, and he said, yeah, no, CPS told us to take you off the list. And so I'm worried now that if something happens between now and then with my housing, that they're going to use that as a reason to push for adoptions and terminate my rights.
They could use that. But, that service, reunification service of the housing, is kind of a dual type of thing. It's the service CPS is supposed to give you, but it's also a service that your county or city and the federal government give to you independently. Now,
hey Vince.
Yes?
I'm not sure if it's just me, but you sound really, really far away. I can't even hear you.
You're going in and out.
I'm not sure if the caller can.
Okay. Mom, can you hear me?
Now I can.
Okay. So we want to make sure that you talk to your housing authority, your local housing authority, to make sure that you can still get that service irrespective of CPS. Okay?
Okay.
All right. Listen,
thank you so much.
Thank you for calling and thank you for listening. And, call us in a few weeks and give us an update on what's going on. Okay. Thanks, Ashley. 2 minutes. All right. Hey, Cynthia, can you hear me good now?
It's weird. It goes in and out, and you sound like you're very far from the speaker. But right now, it's okay.
Yeah, and I've been having some technical difficulties since I'm doing the show remotely and not in the studio. Did you want to tell our listeners anything before we take our first break?
Sure. So as we mentioned, our website, which is cpsattorneyrolodex.com. It is growing fast, and we've added a new part to it for family members. So if you are a family member and you have a CPS case, or you're interested in filing a lawsuit against CPS, what you do is you go to the same website, cpsattorneyrolodex.com. You enter your information, and when we have an attorney in your area, you will be notified immediately. So that is something new that we've added for parents and family members.
Wow, that sounds great.
Yeah, so it kind of helps take the weight off of the parent, give them some hope, allows us to find attorneys in that area and then have them come on and we connect the attorneys and families together so that then they can fight their CPS case.
Great. Okay, Cynthia, I think it's time to take our first break this evening. We're going to be back with more stories, more questions, more calls. So this is The Secret, How to Fight Child Protective Services and